A common case that I see is a case that begins with a motor vehicle stop, where the individual has committed some traffic infraction. In a recent case that I had, the individual that I represented was charged with both driving under the influence and with possession of drugs. Well, initially the police officer issued a citation for the traffic offense. And we're all familiar with the situation where we get pulled over, we sit in the car, the police officer goes back to his vehicle, he spends about 15 minutes writing up a citation, brings it back to you, explains to you what to do. All of that happened in this case. The police officer then turned and started to walk back to his car. My client assumed that at that point that this was over with. The police officer then turned around, came back, and said to him, would you mind stepping out of the car and having a discussion with me? Clients don't interpret would you mind as an option. They interpret it as get out of the car and come back and speak with me. At that point, the officer made the DUI consistent observations and then said, if I call for a drug-sniffing dog, will we find drugs in your car? At which point my client said, yes, I've got marijuana in the car. I felt that the state trooper violated the defendant's constitutional rights. The traffic stop I felt was appropriate. The client was speeding, the police officer had a radar gun, properly calibrated, and so I didn't challenge the initial stop. I challenged what happened afterwards, and I was able to convince the judge that what happened afterwards was unconstitutional, and he suppressed all of the observations that were consistent with driving under the influence, as well as the drugs that were also found. The judge concluded that this second confrontation was unconstitutional because the client did not believe that he was free to terminate the encounter and leave the scene. District Attorney's Office wound up dismissing the case.